Good morning and welcome to our Autumn 2024 Construction and Engineering webinar. My name is Catherine Andrews and I'm a partner here in the construction team at Birketts. Could we have the first slide, please? So just to introduce you first to your speakers. So first we will have Katrina Bretten. She is a senior associate in the construction team on the non-contentious side. She assists developers, employers, contractors, all members of the supply chain on project documentation at the outset of our projects and provides project management support during those projects. We then have our guest speaker from our corporate defence and regulatory team, Julie Gowland. Julie deals with all aspects of criminal law at magistrates and Crown Court level, as well as having experience in prosecutions with regulatory bodies such as the Health and Safety Executive, the Environment Agency and Trading Standards, and she also deals with licensing matters. Finally, we have Stephen Williams, a solicitor on the contentious side of the construction team, who's going to look at some current case law. Could we have the next slide, please? So this is just a little bit about Birketts. Hopefully you are familiar with our firm and have been to some of these webinars previously. So we are a full service law firm and have offices throughout East Anglia, London, Sevenoaks, and most recently, hope you've seen in the news that we've now opened our new Bristol office. So if we could have the agenda, please, just to let you know what we're going to talk about today. Firstly, as it continues to be a key topic in the industry, Katrina is going to look at management of project risk under the Building Safety Act. Then with her health and safety hat on, Julie will look at the Health and Safety Executive's approach to intervention, prohibition and improvement notices and the process to challenge those. And finally, as we've mentioned, Stephen will look at some recent case law. Then we'll come back for a short Q&A session at the end. There's an opportunity to put your questions to the panel in the chat function on the GoWebinar portal. Nobody else sees those except me, so please feel free, don't be shy, put your questions through. We've had some in advance as well, which is great, so we will get through as many as we can, and if we can't get back to you, we'll try and do that separately afterwards if we don't pick up your question. The session is being recorded and will be circulated to delegates afterwards along with a copy of the slides. This should be within about the next week. Also, all our webinars are on the Birketts YouTube channel should you want to follow up on anything that we've discussed. So if we could have the next slide, please. And without anything further from me, I'll now hand over to Katrina to discuss project risk under the Building Safety Act. Thanks, Katrina.
Thank you, Catherine. So as she mentioned, I am going to give a reminder of some of the key risks to construction projects which have arisen as a result of changes imposed by the Building Safety Act and identify some of the practical ways in which those risks can be managed through the supply chain. Next slide, please. The first thing to mention is that from the 1st of October last year, new duty holder obligations were introduced as part of these ongoing reforms. These obligations apply to all projects where building regulations apply and are designed to ensure that individuals and organisations who commission, design, construct or refurbish buildings comply with those regulations. Whereas duty holders under the CDM regulations are required to ensure that construction projects are safe to build, use and maintain, duty holders under the building regulations are also required to ensure that completed buildings will be safe to occupy. Next slide, please. Parties are automatically deemed to be duty holders by statute. This means that in practice, the duty holder roles will be undertaken by a number of different individuals or organisations, which we highlight here. The thing to note in respect of contractors is that this will include all individuals and organisations who actually carry out building or construction work on site. So it will include subbies as well as main contractors. Next slide, please. Parties should note that there's a legal duty to ensure that all duty holders are competent to undertake their roles, or that the person has the appropriate supervision if they're in training. Individuals must demonstrate the appropriate skills, knowledge, experience and behaviours, whilst organisations must demonstrate that they've got the requisite organisational capability. Parties must therefore keep a written record of the steps that they took to satisfy themselves, both that the organisations or individuals they appoint are competent to perform their role, but also that the appointments comply with the requirements of building regulations. Next slide, please. Unfortunately, there's not time today to highlight all of the varying obligations which now apply to each duty holder, but I highlight here some key overarching obligations which are applicable to all duty holders on all projects. In addition to the competency requirement, all duty holders must work together to ensure, or take all reasonable steps to ensure, that work is planned, managed and monitored so that it's in compliance with the relevant requirements. They must cooperate with the other duty holders in order to ensure that the building work itself complies with the relevant requirements. And finally, they must notify the building safety regulator of any change to the duty holders. Next slide, please. Now, I did just want to highlight some specific obligations which relate to higher risk buildings. Firstly, it's the client who's responsible for managing the application for building control approvals. The client must also put in place the record of information known as the golden thread, which is relevant to fire and structural safety issues. Whilst both the principal contractor and the principal designer are responsible for storing that information, in practice, it's going to be all members of the supply chain that are required to provide information up the chain to be included within that golden thread. The client must ensure that the principal designer and principal contractor have in place a mandatory occurrence reporting system, and it's the principal contractor who's obliged to operate that system and submit reports to the building safety regulator. Finally, the client must tell the building safety regulator if an individual or organisation is appointed that has been issued with a serious sanction within the last 5 years. Now, this covers all appointments made in respect of the project, whether by the client, the principal designer, or the principal contractor. And a serious sanction can be matters such as a compliance notice, which refers to a contravention or likely contravention of a relevant part of the Building Act 1984, or a report published by the Inquiries Act 2005 that finds an appointee's action or inaction resulted in either a death or a likely contravention of any requirement under either the Building Act 1984 or the Health and Safety at Work, etc. Act 1974. Next slide, please. Those responsible for planning building work relating to high-risk buildings will also need to comply with the new building control regime. This means that approvals from the building safety regulator must be obtained before works can commence through the introduction of Gateways 1 and 2. Gateway 1 establishes an enhanced planning process in that it requires the applicant to demonstrate to the local planning authority as part of their planning application that fire safety considerations are inherent in the initial design. The Health and Safety Executive has, since August 2021, been appointed as a statutory consultee to consider all planning applications relating to high-risk buildings to ensure that fire safety is addressed as part of the design at the first opportunity. Gateway 2 is the building control approval application stage. This acts as a hold point for all applications relating to higher risk buildings, in that the building safety regulator will review the design in detail to ensure that it meets the functional requirements of building regulations, and work cannot commence until such time as this approval has been obtained. Gateway 3 provides another hold point in that a high-risk building cannot be registered with the building safety regulator until such time as the building completion certificate is issued. Typically, we expect the obligation to submit the application will fall to the contractor with input from the client and the professional team. However, as part of this process, the client, the principal designer and the principal contractor are each required to sign a declaration confirming that, to the best of their knowledge, the higher risk building has been built in accordance with the approved plans and complies with the regulations. The building safety regulator will then consider the golden thread of information, consult with statutory consultees such as the Fire and Rescue Service to review that information, and once satisfied, the building can be registered with the building safety regulator and then occupied. However, these hold points pose an obvious risk to project timetables in that they require sign-off from the building safety regulator before either works can progress or the building can be registered and subsequently occupied. For example, only last week, Construction News reported that 12 of the 606 applications for approvals relating to high-risk buildings and 4 applications relating to design and construction of new high-risk buildings had been approved within the statutory 8-week time period. The vast majority of applications had either been rejected due to a lack of information or simply not determined on time. Now, this clearly will have an impact on programme. Parties should also note additional hold provision will apply where there's any change to the approved design made either before or during construction. This is because whilst all changes must be logged in a change log, before any controlled change is carried out, the client must ensure that a record is made of that change and a revised version of any approved document is produced to show the controlled change. There are then additional requirements where the control change is notifiable or major, in that the client must notify the building safety regulator before undertaking a notifiable change, and additional building safety regulation approval is required before implementing a major change. Now, whilst the time period for determining applications for major changes is 6 weeks rather than 8 weeks from receipt of a valid application, we do nevertheless anticipate that this has the propensity to cause significant delays to the programme as the regulator continues to grapple with this new administrative burden. This risk will obviously need to be allocated in the contract. Parties should also note that the building safety regulator has the power to reclassify any controlled change. So if there's any doubt as to the nature of the change, it will often be best to err on the side of caution, make the application for approval as a major change, and allow for the 6-week determination period. Next slide, please. Looking more widely then at some of the additional risks associated with projects following Building Safety Act reforms. Obviously, much has been written about extended limitation periods, which for certain claims relating to dwellings has been extended from 12 years to 15 years, or even 30 years for historic projects for claims under the Defective Premises Act, or claims under the construction product regulations where they relate to cladding issues. There's also scope for claims under the construction product regulations where a building is found to be unfit for habitation, and or breaches of the building regulations where works are found to be non-compliant, or where the building is failed to have provided a habitable dwelling. For landlords and developers, there's the possibility of remediation orders to require them to remediate or fund the remediation of fire safety or structural defects. And finally, building liability orders can apply where it's no longer possible to pursue the party responsible for the fire safety defects, whether that's because that party is now insolvent or otherwise ceases to exist. In such circumstances, a claim can be brought against an associated company of that original party where it's just and equitable to do so. Now, this is a major departure of English law's standard position, where the corporate veil protects parties that sit behind it. Next slide, please. Turning then to consider some of the practical steps parties can seek to take to mitigate these risks. Firstly, in respect of the competency requirement, obviously records will be key, but parties should also have regard to the Industry Competence Steering Committee. Now, this oversees 12 steering groups which have been established to determine specific competency requirements of various occupations within the industry, ranging from engineers, fire risk assessors, site supervisors, and installers. As for organisational capability, companies can apply to a recognised assessment body for independent certification under the Common Assessment Standard. This can provide some reassurance that the organisation has the requisite capabilities. Looking at architects specifically, the Architects Registration Board has greater powers now to monitor the competence of architects. They can remove an architect from the register where they fail to satisfy those competency requirements. And as of January this year, the ARB introduced a new CPD system, which includes fire and life safety as a mandatory topic. A new code of conduct is also expected next year. In respect of building inspectors, obviously they must be registered with the building safety regulator, otherwise works to a site that they're overseeing must stop. There's been much written in the press about that already, and given the shortage of building inspectors generally, that's obviously a real risk. And finally, principal designers have had a certification standard since last year. At the first stages of procurement, then considering these issues, clients should request and contractors and designers should look to provide evidence of how they're satisfying these specific competency requirements. Clients may, for example, ask for evidence that organisation has been certified under the Common Assessment Standard, seek to include as a requirement in tenders, for example, that evidence is provided, and as we've mentioned in relation to architects, it may be possible for clients to request evidence that they're filling those CPD requirements. As for delays to the project timetable caused by the gateway and change control processes, it's clear that early engagement with contractors and the design team will be crucial. So we may see greater use of pre-construction services agreements, for example, as parties seek to complete or settle the design as much as possible prior to Gateway 2. Similarly, we may see less opportunities for value engineering, as delays associated with the change control process may render that a false economy moving forward. We also expect parties to expressly address the consequences of any delays in the building control approvals regime, and to include specific obligations regarding record keeping and the timely provision of key building information in their contract documentation. It may, for example, be included as preconditions to practical completion. Next slide, please. Looking now more generally at some practical steps parties can take. Firstly, it's obviously important to ensure that the contract is fit for purpose. Employers would be best advised to use the most recent form of the 2024 edition of the JCT building contract, for example, if that's the preference, as that's been updated to reflect changes in legislation. This also applies to contractors appointing members of their supply chain as the editions of these subcontracts are published. However, whilst earlier versions of the JCT suite will eventually be taken out of print, it's not mandatory to use these latest versions. Parties are still free to contract on whatever terms they choose, albeit they would be well advised to ensure those terms have been amended to include other express provisions within the contracts, terms such as extended limitation periods, the requirements to provide information and to cooperate with duty holders, but also for information to be included within the golden thread. We'd also expect parties to include confirmation or warranties in respect of competency requirements, enhanced provisions regarding the construction product regulations, and requiring compliance with building regulations and the gateways processes. One of the criticisms levied against the industry in the latest report following the Grenfell inquiry is that parties simply did not understand the scope and nature of their contractual obligations. By avoiding reliance on general or implied terms and instead setting out building safety amendments as express contractual obligations, there can be no argument that parties were unaware of their responsibilities. Now, one other point to note in respect of the 2024 suite is it doesn't address the specific risks associated with higher risk buildings. Parties will need to address these risks through bespoke amendments to their contracts. Moving on, collateral warranties will become all the more important in view of the longer limitation periods and additional duty holder liabilities imposed relating to fire and structural safety. As there's more scope for liability and more scope for that liability to persist longer, it will be ever more important to ensure that parties have the requisite contractual recourse to those that were actually responsible. For contractors and members of the supply chain, this also means that they're not stuck with liability for other people's shortcomings. Now, due diligence and industry accreditations go hand in hand, but employers and contractors alike will need to ensure that they're much more rigorous in that process and raise appropriate inquiries about matters such as competence, organisational capability, whether or not a party has been subject to serious sanctions, and whether they and equally their products benefit from appropriate industry accreditations and certifications. And finally, due to extended limitation periods, it's important to ensure that parties have the necessary professional indemnity insurance in place for the totality of the limitation period. Next slide, please. Finally, then, just to wrap up on this section, I've set out some thoughts just as takeaways. I'll now hand over to my colleague, Julie Gowland, who'll talk to you about the Health and Safety Executive's approach to notices on construction projects. Thank you.
Thank you very much, Katrina. That was very interesting. Good morning to you all. As you've heard, I'm Julie Gowland, a partner within the Regulatory and Corporate Defence team here at Birketts, and today I'm going to be speaking to you about the HSC's approach to intervention and enforcement, statutory notices, and the process in which to challenge those notices. Next slide, please. As I'm sure many of you are aware, under health and safety law, as an employer, you have a duty to protect workers and others from risks to their health and safety. Health and safety law is mostly enforced by the Health and Safety Executive or the local authority. The responsibility of enforcement depends on the type of workplace. The main piece of legislation, as Katrina has already referred to in her presentation, is the Health and Safety at Work Act 1974. This Act imposes a general duty on employers to ensure, as far as is reasonably practicable, the health, safety and welfare of their employees at work. This includes providing safe systems of work, safe equipment and adequate training. This year represents its 50th year anniversary, and it's fair to say we have come a long way. Since 1974 onwards, fatalities have steadily declined. Since 2013, there have been fewer than 150 fatalities in every year. In 2023, there were 138 fatalities, but there's not yet been a year with fewer than 100 fatalities. The construction industry remains one of the most dangerous sectors. It accounts for 45 fatalities in 2022 and 2023. The three most common causes being falls from height, being struck by a moving object, and being struck by a moving vehicle. Now, after a real drop in the number of statutory notices being issued during the pandemic, there appears to have been a notable increase in enforcement notices issued last year. The HSE issued approximately 8,000 notices. 6,000 of those were improvement notices, and approximately 2,000 related to prohibiting work activity that placed people at risk of death or serious injury. This compares with approximately 6,900 notices being issued in 2021 to 2022. The construction industry is heavily regulated. We know there's a real risk of people falling from height, being struck by machinery or moving objects. The chances of you being subject to a HSE visit is arguably higher than in other industries. Next slide, please. So when might you hear from the HSE? No one has to be actually hurt for an offence to be committed. There only has to be a risk of harm. If you do not comply with the law, you could be committing a criminal offence, and you could receive verbal or written advice from an inspector, an improvement or prohibition notice, or you could be prosecuted. Notifications of contravention are issued if the HSE inspector considers that there has been a material breach. In those circumstances, they will send you a letter. That letter must include the law the inspector considers to be breached, the reason they believe that it's been breached, and inform you that a fee is payable. Notifications of contravention are usually reserved for minor breaches, and they would ordinarily contain information to assist you in rectifying that breach. In the case of a more serious breach, or if the inspector considers imminent danger, statutory notices may also be served. Under Section 21 of the Health and Safety at Work Act, improvement notices can be served if an officer considers that a person has breached health and safety law or they think a breach is likely to occur. The statutory improvement notice will require steps to be taken to rectify the breach. In some instances, you will be given an opportunity to correct what you're doing wrong before an improvement notice is issued. The approach taken does very much depend on the individual inspector. Almost certainly, the HSE will revisit to ensure that appropriate steps have been taken. You will be given at least 21 days to comply with the notice. If you consider the time afforded to be too short, then you should write to the inspector and inform them. If, for example, a condition is that you are required to implement some training and that cannot be facilitated in the time provided. Under Section 22 of the Health and Safety at Work Act, a prohibition notice can be served when an inspector deems that a certain activity includes a risk of serious personal injury. As the name suggests, the notice has the effect of requiring an immediate stop of the identified activity. For example, if you need to use a tool that has been given a prohibition notice, this means that the tool is unsafe and you should not use it until it has been made safe. The inspector will need to be convinced that the activity can be performed safely before permitting it to be resumed. A prohibition notice can be served on any person in control of a process or a piece of plant subject to the relevant statutory provisions. So that could include an employee who may not be aware that the activity is unsafe, and is acting in accordance with his or her employer's instructions. In such circumstances, the employer should be contacted to advise them of the situation and the proposed notice. The inspector will almost certainly consider serving a notice on both employer and employee. Next slide, please. So what to do if you receive a notice and you wish to challenge them? Somewhat unusually, you may think, appeals of the statutory notices are dealt with by the Employment Tribunal. If the appeal is successful, the notice can be cancelled, confirmed, or modified. Any notice should set out the details as to how you appeal the notice and inform you that you have 21 days to appeal, starting with the date the notice is served. An application to appeal out of time may be allowed, but there would need to be good reason. The effect of an appeal is to suspend the improvement notice until the appeal is heard or withdrawn, ensuring that you can then focus on the appeal process without immediate enforcement action. A prohibition notice is not suspended, but you can apply to the Employment Tribunal for a direction that it be so. Our advice is to not ignore the notices. Non-compliance is a criminal offence under Section 33 of the Health and Safety at Work Act, punishable by a fine or imprisonment or both. Engage in discussion. Speak to the inspector who issued the notice. They should engage in discussion with you regarding how the required improvements can be achieved. They may provide additional guidance in a covering letter that accompanies the notice. That should be seen as advice and not part of the notice itself. Assess the notice. Carefully review it to understand the contraventions identified, the remedial actions required, and the compliance period provided. Seek clarification from the inspector if any aspects are unclear. And seek specialist legal advice regarding the notices and whether indeed there are grounds to challenge. Consideration of the HSC website and in particular the enforcement management model and the HSC enforcement policy will help you identify if there are grounds for appeal. Next slide, please. Fees for intervention. As the name suggests, a fee for intervention is a fee that is payable if the HSC visit your workplace and after an inspection they identify a material breach resulting in a written notification of that opinion. A fee is charged for the time taken by the HSC to identify that issue and help the company put things right. A material breach is a contravention that, in the opinion of the HSC inspector, is serious enough to formally write to the business, requiring action to be taken to address the breach. Fear not, businesses that are inspected and found to be meeting their legal requirements will not be required to pay. The construction industry is most frequently the subject of an FFI charge. It's one of the most regulated sectors due to the high risk of accidents, as I stated, falls from height, equipment misuse, hazardous environments, and common breaches include inadequate risk assessments, poor scaffolding, or insufficient PPE. Next slide, please. Thank you. In April of this year, the fee for intervention went up to £170 per hour, and this can be charged to employers, self-employed who put others at risk, public limited companies and such like. The amount charged will very much vary depending on the time spent, but it can include inspectors' time attending site, speaking to staff, taking statements, researching issues and liaising with experts. Fees for intervention can be quite significant and often run into the thousands, and as such the HSC can offer businesses flexibility in paying the FFI. Next slide, please. If you disagree with the sum charged, you can appeal it. I recommend that you do this often if you do scrutinise the fee for intervention, as often mistakes can be made. For example, the HSC may seek to charge you for the full site visit, yet the material breach only relates to a very small part of that. You may wish to challenge on the basis that experts' fees are not reasonable. Likewise, if the material breach is not accepted, that is another ground to challenge. You have 21 days to challenge the fee for intervention via the FFI team at the HSC. After a response from that team, you then have 30 days to pay. If, however, you are still unsatisfied, then you must write to the HSC within 21 days setting out your position. That is then considered by an independent panel of 3 persons, 1 lawyer and 2 health and safety professionals. If your challenge is not upheld, then the original fee for intervention is payable along with the costs of the panel. While specific success rates for FFI appeals are not widely published, some reports suggest that most appeals are not successful. We know that the HSC thoroughly investigates material breaches before issuing fees for intervention. It therefore makes it difficult for businesses to overturn the charges without significant evidence to the contrary. However, my advice is to carefully scrutinise the charges incurred. My personal experience is that where a challenge has been brought, it has been successful. In my view, not enough consideration is given to challenging statutory notices or fees for intervention. They are issued when the company is dealing with other more pressing matters, often in the wake of a serious incident that has greatly impacted their workforce, and as such, the company has a number of other things on its mind. Complying with a statutory notice is essential to avoid prosecution. However, if you believe the notice is erroneous, appealing is your right. Prompt action and seeking legal assistance are crucial in navigating the process effectively. Birketts specialist regulatory and corporate defence teams and their safety specialists are on hand to advise on all health and safety related matters. And on that point, I'd like to just mention that we have our annual Health and Safety Conference taking place at 1 Moorgate in London on the 17th of October 2024, and we'd be delighted to see as many of you as possible attend. Thank you for listening. I will now pass you over to my colleague Stephen Williams, who, as you're aware, will provide you with a case law update.
Thank you very much, Julie, for an interesting insight into health and safety matters. Good morning, folks. I'm Stephen Williams, and I'm a construction dispute specialist here at Birketts. This morning, I'll be providing a brief update on some recent interesting case law. I'll be keeping it brief as I know there are lots of questions that have come in for the panel, and we're keen to answer as many of those as possible. So the cases I'm discussing today cover JCT termination rights. There's a recent Court of Appeal decision on this, and it's caused a bit of a stir. Limitation, that's an NHBC case, which are quite rare to have. It's quite rare to have an NHBC reported case. Make of that what you will. And lastly, an adjudication case, which provides a recap on the principle of pay now and argue later, and also sets out the court's approach with regards to setting off adjudication decisions. So without further ado, we'll move on to the next slide, please, in the first case. This is the case of Providence and Hexagon, which is a Court of Appeal decision. Court of Appeal decisions are binding on all courts, save only the Supreme Court. So the judgment is very important, and I think it's fair to say that this decision is somewhat controversial. So we might see it appealed to the Supreme Court. So we'll watch this space. So in a nutshell, the parties in this case contracted on the basis of JCT Design and Build 2016 terms, and the case concerns the contractor's right to terminate the contract under the JCT. So in this case, Hexagon was the employer, and you'll see from the slides that Hexagon was late in making payment on two instances. After the first late payment, Providence served a default notice under clause 8.9 of the JCT, which is perfectly entitled to do. That notice, the subsequent provisions of the JCT provide that if the default, i.e. the late payment, is not rectified within 14 days, the contractor may serve another notice terminating the contract. However, payment was made and the contract was not terminated at that point. Fast forward a few months later, in May 2023, Hexagon was again late by 1 day, by which point Providence had served a notice of termination under clause 8.9.4, which allows the contractor to terminate for repeated breaches that have previously been notified. So whether or not that termination was lawful hinged on the court's interpretation of 8.9.4, which deals with repeated breaches. And the Court of Appeal found that a contractor can terminate for a repeated default, even if the initial default was resolved quickly. and within the remedy period, which was the case in this instance. The contract doesn't require the contractor to have had the right to terminate for the first default before it can terminate for a repeated breach. In light of this decision, the risk of a termination for a repeated breach needs to be properly appreciated by the industry, as I think we are likely to see an increase in contractors terminating more regularly for repeated late payments, even if that repeated late payment is late by just 1 day. So let's move over to the next slide, please, and we'll look at some points to consider. So what does this mean for you? So for contractors, great news, you've got a Court of Appeal decision that's confirmed that you have more power to address late recurring payments. However, I'd advise caution not to go gung-ho, because terminating is a nuclear option. It should be considered very carefully, particularly in light of your commercial relationship with the client, because it's a surefire way to spoil relations going forward. And if that's a very important client to you, that might not be the best way to proceed. But employers, well, the stakes are now even higher for late payments. There's a risk of the contract being terminated if you're late on payment more than once, even if it's just by a day. So more important than ever to ensure that you make payments on time. So in terms of action points for both parties then, and really these are key takeaways. I'd firstly review your contracts, understand the termination clauses of your JCT or your bespoke contracts or whatever other form you may be using, particularly around payment defaults. Employers should also be implementing robust payment systems, ensuring their payment processes are watertight, sufficient to satisfy their contractual obligations in order to avoid late payments. Parties should also keep a clear record, maintaining records of all payments, notices, and communications. And communicate early. This is just good advice and good practice for any project. But if a payment issue arises, sometimes banks go down. Open a dialogue immediately to avoid the issue being unnecessarily escalated. And from the outset of contracts, before you've entered into contracts, consider amendments, consider amending your contracts. If you're an employer and you don't want your contractor to have such a extensive right to terminate for repeated breaches, deal with that in your schedule of amendments. Of course, it's subject to negotiation, but it may be a way to deal with this before you end up in this situation. And of course, as ever, seek advice early. If you're unsure about your obligations, if you're unsure about how your termination rights may be exercised, come and speak to us and we'll be happy to advise. That's the key takeaway, I think, for this issue. So if we move over now, please, to our next slide. This is the case of Peabody and the NHBC. I suspect many of you are aware of NHBC policies. As I mentioned, there aren't too many NHBC cases, but this one is all about limitation. Essentially, the NHBC was arguing that the case was brought outside of the limitation period. For those of you who aren't familiar with the concept of limitation, your claim must be issued at court before the limitation date, otherwise you will be statute barred from bringing your claim. And you start counting from the date on which the cause of action accrued generally, and you have 6 years if you're operating under a contract, or 12 years if you're operating under a deed. So let's look at the facts of this case then. Catalyst, to whose right Peabody succeeded, engaged the building contractor Vantage, and construction began in December 2015. Unfortunately, Vantage faced some financial difficulties, which ultimately culminated in administrators being appointed in June 2016. Now, part of the project was covered under the build mark policy against various risks, and that risk included contractor insolvency before practical completion. Now, after Vantage went bust, Catalyst engaged Stack in June 2016 as construction manager, and the construction manager appointed various contractors in order to finish the project. And at the end of the project, the overall costs were around £900,000 more than they were anticipated to be under the original contract sum, and this was a risk that was covered under the build mark policy, i.e. additional costs. If we move over to the next slide, we can look at the policy wording. So when the section applies, it applies if you lose the amount paid to the contractor in accordance with the building contract, or have to pay more to complete the building of the homes. Well, that's this case here, because the contractor is insolvent or commits fraud. And so what the NHBC will do in those circumstances is pay the reasonable extra cost above the contract price. So in this instance, the NHBC was asking the court to deal with the case summarily on the basis that the claim was brought over 6 years from when the contractor went insolvent. And there were lots of submissions about when the limitation date should be. Peabody said, well, it should be from the date that the parties became aware that it was going to cost more to complete the project than the original contract sum. Ultimately, the court reserved its position on when the actual limitation date is, and that's to be decided later. But what it did definitively decide was that the NHBC was wrong. The limitation date is not 6 years from the contractor's insolvency. That's good news for Peabody, because Peabody can now continue its claim. So lastly but not least, let's move over to the next slide, please, and the last case I'll be discussing today. This is the case of CNO and Caldwell, and this case shows how the court approaches a party's request to set off 2 adjudication decisions. It's also a reminder of the principle of pay now and argue later. Some of you may have heard of that principle, and if you haven't, I'll be discussing it shortly. So in this case, there were 2 adjudication decisions. In the first adjudication, that concerned the defendant's failure to issue a pay less notice. The adjudicator was Mr. Latham, and he decided the defendant, Caldwell, must pay the claimant the sum of just over £250,000 plus interest in the adjudicator's fees. In relation to adjudication 2, a true value adjudication was commenced by the defendant, and Mr. Lord decided that the defendant must pay the claimant just under £90,000. So a much better position in adjudication 2. But the claimant challenged the adjudicator's jurisdiction in relation to adjudication 2, and that jurisdiction was challenged on the basis that it's now well established that you can't commence a true value adjudication where you have a notified sum outstanding decided by a previous adjudicator. Notwithstanding those arguments, Mr. Lord, the second adjudicator, decided he had a jurisdiction to continue in the adjudication. So the claimant applied to the court to enforce the first adjudication decision, and the defendant sought to set off the sum awarded in the second adjudication. However, quite crucially, they hadn't asked the court to enforce the second adjudication decision. If we move over to the next slide, please, we can have a look at how the court dealt with this. So firstly, the court said that it's generally not permitted to set offs are generally not permitted. You can't generally have a position where you have more than one adjudication decision, and you're trying to set them off. And that's because the court's policy is to enforce these decisions summarily and expeditiously in order to keep the money moving between the parties. The pay now, argue later principle, in essence. The court was also rather unimpressed that a true value adjudication had been commenced before the previous adjudication decision on the notified sum of $250,000 had been paid, and that's because it's well established that one cannot commence a true value adjudication without having first paid the amount awarded in the previous adjudication, and that's you're fundamentally just not permitted to do that, and that's settled law in a number of cases now. So ultimately, the court decided refused to set off on those two bases. That's all from me. So thank you very much. I'll now pass back to Catherine, who will answer any questions you may have.
Thanks, Stephen. Thanks, everyone. We have quite a few questions that have come in, perhaps not unsurprisingly, quite a few on building safety, which is obviously a big concern in the industry at the moment. Katrina, perhaps I can go to you first with one of those questions. Generally, a question came in to say, under the Building Safety Act, what should be the key considerations in a non-high risk building scenario?
Thank you, Catherine. Well, so non-risk, I'm taking we're meaning non-higher risk buildings.
Yes, that's what I understand. Yeah.
Okay, well, the Health and Safety Executive has a really useful page actually, which highlights all of the obligations for duty holders. The first point to note obviously is that the duty holder regime is mandated by statute. So as long as there are a number of different contractors and designers, obviously there's a client, all of those duty holder obligations will apply. But the main consideration will be competency. As I've said, it's really important, and it's incumbent upon all duty holders to ensure that they have the necessary competence to perform their obligations, and that they cooperate with other members of, with the other duty holders, and everyone is working together to ensure that the building satisfies the requirements of the building regulations.
Thank you. And I think competency is something that's come up in a couple of other questions as well, Katrina. So there was one about how you demonstrate competency. Is it do you have to show you're suitably qualified in terms of the Building Safety Act, or is it sufficient just to show you're reasonably competent?
I think competency is going to vary between the duty holders, and also, depending on the role that they're playing. So obviously there'll be different competency requirements for a contractor as opposed to a specific designer. But the key thing here is that you do need to be qualified in your relevant area. So it's not appropriate for trainees to be undertaking the duty holder regime. They do need to be supervised in their work by somebody who is appropriately qualified.
Thank you. Julie, I've had a couple of questions in for you as well. There's one here, with the number of notices being issued, you commented was on the increase. Are there any ways that a company can proactively prepare for inspections to try and avoid being on the receiving end of one of these notices?
Yeah, good question, Catherine. Thank you. So there are a number of things that companies can do to ensure that they don't receive those notices. So one would be to conduct regular internal audits, so inspect your premises, ensure that workplace practices, equipment, the environment generally meets legal requirements and industry standards, and document what you do. So ensure that you keep up with any changes. Katrina obviously referenced the HSC website. They have a wealth of information. So I would recommend that anyone who has any queries directs their attention there. But ensure that you have clear policies and procedures, including risk assessments and control measures for the work that you're undertaking. and ensure that your employees receive adequate training in health and safety and obviously compliance. They should be aware of the potential hazards and then know how to mitigate them. And really a lot of that does come to you trying to foster a safety culture where employees feel responsible for adhering to, but also reporting safety concerns. I would encourage that senior management actively engage in those initiatives and lead by example from the top down. Obviously, you can engage external auditors. I've already referred to the fact that we have a number of safety specialists who are ex-principal inspectors for the HSC who undertake audits. So you have a rigour of a HSC inspection without the fear of enforcement. And then, of course, keeping on top. So ensure that you maintain equipment, you undertake risk assessments so that you can identify hazards and implement control measures, and keep communication open. Sadly, you know, of years gone by, used to be that you would know your local health and safety executive inspector, you would have a good relationship with them. It's less now about engagement, and sadly we have moved more towards enforcement, but where possible keep open communication with them, and conduct mock inspections, because that will identify any issues and highlight any areas that need improvement. So, and finally, address issues promptly. You know, don't leave them. If there's an issue that's identified, take corrective action. So hopefully there's a few sort of takeaways there for the audience.
Thank you. And another one that came in was about training. So is it sensible to train employees about these notices and you know, what to look for and so on? Is there guidance for that?
Absolutely. I think it's really key and crucial that employees are trained about improvement and prohibition notices, so that each employee understands what the notices mean, the circumstances under which they are issued, as well as the impact, you know, the consequences of receiving a notice, disruption of work, the legal implications, financial penalties, and of course, harm to a company's reputation. I think making it clear to each employee that they have a role to play in maintaining those levels of compliance and preventing the notices being issued by following safety and operational guidelines. So my advice would be that it's incorporated as part of health and safety training. Companies, I think a really useful tool is for companies to use real life examples or case studies where improvement or prohibition notices have been issued in that industry, to show how non-compliance can affect business operations, and sort of refresher training, so that it is incorporated perhaps in part of the induction program, and then for companies to sort of monitor and reinforce compliance. I think by, you know, being very clear in terms of how you communicate, regular training, practical tools such as what we've talked about, then employees will better understand the role that they have in preventing improvement and prohibition notices being issued. So hopefully that answers that question, Catherine.
Thank you. Stephen, got one for you on the JCT termination case that you spoke about. It's obviously quite new and quite topical. The question was, can we prevent the contractor from being able to terminate for repeated breaches?
Yeah, it's an interesting one. I mean, whether the contractor can terminate for repeated breaches very much depends on you know, the wording of your contract. So if it's already in place, that is. If it's not already in place, we can assist you with preparing a schedule of amendments to the JCT form, which would alter the contractor's right to terminate for repeated breaches if you didn't want those rights to be so extensive. Those terms will.
I think that we're going to see quite a lot of amendments of that clause now, aren't we?
Yeah, I think so. Yeah, I mean, that's obviously subject to negotiation, but yeah, that's how you do it.
Thank you. Katrina, just dotting back to you, another one about duties under the Building Safety Act. There's a question about whether the principal designer role is the same under the Building Safety Act as under the CDM regulations.
Thank you, Catherine. Yeah, that's a good question. The language of both the CDM regulations and the building regulations is very similar. They do use the same terminology, but they are two separate obligations. The same person can be appointed as principal designer under the CDM regulations and also the building regulations, provided obviously that they are competent to do so. But it is a separate role. So in your contracts, the building contract, for example, you will see in the new JCT 2024 suite that there is a specific provision asking employers to identify the principal designer for both CDM regulations and also now building regulations. And obviously the consultant who is appointed to do that will need to have specific services relating to both roles. The only other thing to mention is that obviously the requirements of the CDM regulations and the building regulations are slightly different. As I mentioned, the obligations under the CDM regulations relate to ensuring that a building is safe to use, manage and maintain, whereas under the building regulations, the emphasis is on ensuring that that building is safe to occupy.
Brilliant, thank you. There's one more general question that came in, which I'll just touch on. We've been asked about what we expect the impact will be from the implementation of the Procurement Act 2024, which was due to come into force in October. We thought that was just worth picking up because actually we've just had a statement from the government announcing an intention to delay the commencement of that act to a new date in February next year. So we think that might well be welcomed by authorities who are currently trying to update all their documentation and make those changes. But obviously it comes from the new government, and they want to issue a new statement going with it to reflect their priorities for public procurement, which will replace the statement that was put out in May by the previous administration. So it will be interesting to see how those priorities will change, but we haven't got that information yet. So if we can just note that for everyone and watch this space. So we're coming up to our midday deadline. So I hope the session has been useful this morning. When the session ends, you'll be asked to complete a feedback form, which we always find really useful, but also it gives you the opportunity if there's anything particular you'd like us to cover in another session. And also any points you'd like one of the panel to follow up on, would be happy to get in touch. Also, just finally, date for your diary. The next webinar, so our winter webinar, is on the 20th of November, and we'll be sending some more information out about that shortly. So many thanks for everyone for joining, and have a good day. Thanks. Bye.
Thank you.